insurance during the claims process, let's say they agree to cover a claim for a policyholder and they provide an estimate for that loss to the policyholder and say, hey, this is the amount that it'll cost to put your house in its pre-loss condition. The policyholder takes that, and this is a common scenario that I have, and a lot of my clients have come to me with this exact issue. And they say, hey, I've taken this amount to a couple contractors to see who can get this work done. And it doesn't seem that any contractor can get the work done for the amount that they're offering. I'm not sure what my next step is. I'm not sure what is the appropriate thing to do. What do I do? And, in unfortunate situations where policyholders just don't know who to talk to at all, they end up stuck for months and months and months without having any kind of substantive recovery for their loss because insurance hasn't paid out what's fair. Now, a lot of times these estimates provided by insurance are written by adjusters that have no background as contractors. They have a very superficial knowledge of these estimates and what work needs to be done, but they don't have an in-depth understanding of all the ins and outs of what needs to be done to adequately restore the property to its pre-loss condition. Whether this be for a commercial property, a residential property, whatever it may be. So the good thing here is there is a specific regulation that's on point that goes directly to these types of questions. So let's say the insurance company does this, the policyholder is having an issue. The regulation that we would use is Regulation 2695.9, which essentially indicates that if there's a disagreement and the policyholder does not believe the amount paid by insurance is fair, they can obtain their own written estimate and provide that estimate to insurance. Upon submission of that estimate, insurance has only three things they're allowed to do. First, they can pay out the difference. They can pay out the difference between the estimate obtained by the policyholder and their own estimate. That's rare. That doesn't happen very often. More oftentimes, we'll see insurance coming back and doing the other two options. The third option is adjusting the claim, actually going in and fairly adjusting the claim. That's done sometimes, but more often they'll go with option number two, which is bringing in a contractor. They'll bring in a contractor who's one of their preferred vendors, and this preferred vendor will provide another quote. And unfortunately, this is one of the scenarios where there's a lot of manipulation of the system that's used in these cases. These preferred vendors are receiving jobs from the insurance companies. Now, there's a whole another reason why that shouldn't be allowed and why it's not allowed under California law, but that benefit they're receiving from these insurance companies is making them beholden to these insurance companies, and then they'll come back in with low quotes that match or equal what the insurance adjuster put together. And oftentimes there's no justification or reason why they've cut out everything from the policyholder's written estimate. Needs to be an explanation. The insurance company needs to describe and explain why those items were taken away. And that often doesn't happen. So again, those are the three options. If you run into a scenario where you're dealing with the battle of the estimates, look to California Code of Regulations 2695.9. It will explain what you need to go through to have insurance properly adjust your claim.